Hello, YouTube, my old friend. I've come to speak with you again. Hi, I'm Vince White. I'm an employment attorney, and we are answering publicly posted questions from YouTube users, getting folks the answers they need from an employment attorney. Because we hope it's helpful. And if it is helpful, like and subscribe, because that would in fact help me to help more people just like you, potentially, assuming you have a job. If you don't have a job, I probably can't help you. Which is not a jab at the jobless. We've all been there. We have a question here from YouTube user NoNo1026 who asked us, hey Vince, when should an attorney speak or get letters from witnesses? My goodness. So the answer is it depends, specifically on the situation. And there's two considerations. The first and most obvious consideration, excuse me, computer. I don't know if you can hear that, but my computer being very agitated with me. I think it's over. All right. So the first and most obvious consideration is that witnesses may experience some pressure from the employer, directly or indirectly. Subtle pressure is a reality, right? There's a lot of people who feel very brave at the outset of a case and say, I'm going to support you, I'm going to do right by you, and later on, they got kids to feed, and they're a little worried about their job, and it can be difficult to get them to testify willingly. You might have to force them to testify. So that's the obvious consideration, and sometimes I do really like to lock those people down vis-a-vis the method of getting them to sign an affidavit, right? I'm not saying they would lie later, but I am saying I'd rather have an affidavit if I think someone's story might change under pressure, or something might happen to them, or they might move away, or they might die, or they might lose the capacity to testify in some way, or any number of things might happen, right? So often I will go early and I will get affidavits signed by folks to lock them into their testimony, to make sure that their sworn statements are true and accurate and remain unchanged, shall we say. Now, there's a second consideration here that you need to think about. If you're running around getting affidavits from employees, and you're in a jurisdiction where the employer could purchase confidentiality and non-disparagement from your client, then you have to some extent squandered something your client could choose to sell, right? And this gets into a complex area of the law in terms of employment law. In certain jurisdictions, most jurisdictions realistically, you are allowed, in a settlement of a workplace sexual harassment or workplace discrimination case, you are allowed to have provisions in there locking in confidentiality between the parties and potentially non-disparagement provisions between the parties. And that is true even in some jurisdictions that purport to have laws that don't allow that, right? Like New Jersey claims to have laws to this effect, like, oh, you can't do that, but their laws are completely ineffective and nonsensical, and you can in fact do that, right? It took defense attorneys less than 2 months to work around that, and everyone knows the law as it went in was never meant to work, or if it was meant to work in New Jersey, the people who drafted it were so desperately unintelligent that they just didn't have the wherewithal to take 10 minutes and draft a law that would actually work. And I have videos about this. Laws are often drafted by interns from high-end universities, and interns from high-end universities are not particularly valuable. Just to be honest with you, they don't really know how to do things yet because they're, not experienced. That's probably why they're interning. And when they try to write laws, and those laws come up against the best efforts of highly compensated, highly experienced defense attorneys, those laws often are ineffective or improperly drafted, right? And that's giving them the benefit of the doubt that those politicians meant for those laws to actually work. But I digress. Now, so if you're in an area where you can, in fact, have those provisions in a settlement agreement, then your client's silence on this topic is something your client could choose to sell. It's actually something of quite a significant value in many of these cases, right? I've certainly had cases where the settlement offers are all contingent upon confidentiality and mutual non-disparagement. And the settlement offers might be double, triple, quadruple the potential valuation of the case. And I don't engage in blackmail because that would be unethical and detrimental to my license. But sometimes defendants blackmail themselves. Sometimes they'll say, oh my God, this attorney the person hired always does press on the case. And they fight the case in the public eye, court of public opinion. It's bad for the business. We could lose contracts. We could lose customers. Like, I'll give you an example. Apple computers, right? My understanding of Apple computers is that they have an exceptionally high level of female customers. And so perhaps Apple computers, knowing they have an exceptionally high level of female customers who buy their computers, might be really nervous about gender pay gap claims and sexual harassment claims and things of that nature, right? They might choose to protect their good name in certain jurisdictions where they're allowed to by just yeeting money into the world trying to settle everything, right? That could be, hypothetically, something they do to protect their good name. Of course, in other jurisdictions where they can't do that, hypothetically speaking, then everything comes out and is known, and people know what kind of company that is, and we get to see if that does, in fact, impact the sale of Apple computers and iPhones. I suspect it doesn't, because, of course, if you're buying an iPhone, you're okay with slave labor, so you're probably also okay with gender pay gap. I suspect. And, like, yeah, slave labor in China is not slave labor as it was in the United States. Let's be clear on that. I'm not trying to achieve parity between those two systems. Both bad, but not trying to achieve parity, just to be clear, okay? Jesus. I just assume that was coming from someone, somewhere. All right. So if your client can sell their silence and their confidentiality and their non-disparagement, they could get exponentially more from certain employers who are really, really reputation conscious. And your client might choose to do that. Your client might also say, no, it's a principle thing. I won't sign that. I won't do it. To which I say, I applaud you, client, and it's our job to support you. And let's we're going to try this case then. It's going to go to trial because you're not going to want to settle for the amount they're going to give you without those provisions. And they're not going to want to give you more because they primarily want to stop you from speaking to the press and posting on social media and like making their alleged bad behaviors known to the world, right? So those cases, obviously, where the client says, I'm not going to accept confidentiality. I'm not going to accept mutual non-disparagement. High likelihood that's going to trial. So we go back to your original question, when should you speak to witnesses? If you're running around speaking to witnesses, your client's ability to sell her or his silence, which is not a nice way to put it, but is a real way to put it, and we're going to stick with it, it's limited. Because you've already been talking to lots of people. So now the pool of people who have some notion of what's going on, that there's a lawsuit perhaps in play, and bad things happen, that pool has been increased. And as we all know, if more than one person knows a secret, it ain't a secret, right? So as more people know, the employer's less and less interested in confidentiality and non-disparagement provisions because what's the point, right? Oh, sure. I mean, I can get this provision from you, pay you some money for it, but then all these other people you talk to, they're gonna just talk, and I can't stop them. What, am I gonna settle with everybody? Right? That's a reality. So no 1026. And the answer is it depends, which is not satisfying, but there's a lot to think about. There's other things to think about. This is a simplification, but these are the two of the main pillars of consideration that I think about when I think about how to go about locking in witnesses and getting statements from them. Obviously, if you're at the stage where you're in a fact finding or you need discovery, like, it's too late. You have to do it. It's got to go. You've got to substantiate the case. Every case must be worked as if it will go to trial, and you cannot be skipping foundational elements of your trial case just because you're hoping your case might settle. Don't do that. That is not an intelligent move. I hope this helps. These are the considerations that I would think about. And if you're thinking about this on your own and you're pro se, I would urge you, with all the oomph that I can hire an attorney. Things have progressed quite far, it sounds like, and it's probably time to hire an attorney. I really hope. Good luck to you. Like and subscribe. Take care.